All right, we are live. This is the Nowhere to Go But Up podcast, and I'm your host, Sean Dustin. Today I am talking to Curtis Cox, and I will get to that in a moment. I got a couple of housekeeping things to do. Head on over to the Mindset and Overcoming Life Challenges Facebook group. I still have a challenge going on there, an iTunes rate and review challenge, which I've got 4 prizes. Which is show merchandise. So that ends on the 24th. So currently there's only 3 people that are entered. So you definitely will have a chance to win if you go over there and participate in that. Curtis, he's actually a 23-year lawyer. Worked for the public defender's office, I believe in El Paso, Texas, and also as a prosecutor for 13 years. And we will be discussing today everything that has to do with prosecutorial overreach, misconduct, how the system works and is supposed to work, and all of that stuff that's entailed in that. So, Curtis, how are you?
I'm doing very well. I want to thank you for having me on.
Well, thank you for coming on. I mean, I talked to a lot of formerly incarcerated people, such as myself. I believe Joe Martinez is the one who put us in contact, and he's out there doing some great work himself, trying to expose some of these injustices that are happening and exorbitant amounts of time that are being handed out to low-level drug offenders that, really need help, not incarceration.
Yeah, and a lot of that based on my experience, and I guess let me preface what I'm going to say with a little bit more background about myself, because, what I found based on my experience is that if you try to talk about anything related to reforming the criminal justice system, you're going to get a certain amount of people who say, well, just soft on crime. So just so that people understand a little bit where I'm coming from, my initial contact with the criminal justice system in my life was when my grandmother was murdered when I was 14 during a home invasion robbery. And she actually was killed by the grandson of one of her close friends, who was a very troubled individual, but also a pretty bad person, as it obviously turned out. And that was not the thing that made me decide to get involved with being a criminal lawyer. But it does mean that I certainly am able to identify with people who know what it's like to have been the victim of a serious criminal offense. The thing that made me decide to become a lawyer was I actually, after I graduated from college, was living in Austin, Texas, got summoned to be on a jury in a felony drug case. And so I got to experience that part of the system from the inside. And for me personally, it was a life-changing experience because I saw how seriously the people with me on the jury took it, but also how it really was the members of the community making a decision about what they thought of the evidence, what they thought of the witnesses, what they thought of what the police testified to, how they'd handled the case. And that was probably the thing. I think that was the thing that made me decide, okay, I've been looking to get serious about life. I'll go ahead and go to law school. So I did. I was born and raised here in El Paso, Texas, but I'd gone to Austin to go to college. I'd lived there for about 13 years. I ended up going to law school up in the Seattle area. I lived up there for another approximately 12 years. After I became a lawyer, I ended up being a public defender up there for the 5 of the 8 years that I was there. First I did civil cases. I fought about money. I didn't like it. Criminal law is about human behavior, and it's about right and wrong, and it's about what decisions you make about what people are alleged to have done or proved to have done. So I started out on the defense side of things, and then time came. I decided to move back here to El Paso. My parents were getting older, and it was time to move back and be available to take care of them. And by that point, I was a little burned out on being a defense lawyer because it's a huge responsibility to represent people who are accused of criminal offenses, because you're taking some responsibility for what happens with another living human being. And I'd also had a constitutional law professor in law school who had one day told us, If you're interested in trying to achieve justice, go be a prosecutor because they have discretion. As a defense attorney, if you believe that your client's innocent, or you believe that the state can't prove the case, or you believe that there's been some violation of your client's rights or flaws in police procedure, and you can't get the prosecution to listen to you, all you can do is go to trial, do your best, and hope for the best. As a prosecutor, especially before I went into it, my perception was, they have the ability to make decisions. They can, if they think the case is bad, they can drop it. So I moved back here to El Paso. I got a job at the El Paso County District Attorney's Office, and I ended up doing that for 13 years. And 10 of those years, I was a felony prosecutor. And one of the things I learned was that in theory, you have discretion. In reality, it's a bureaucracy, and you're under the control of the elected officials, since basically district attorneys are elected officials, that they are politicians of their own sort, and they respond to their own agendas. And so that's basically the background. Now, what comes up more and more so these days in the context of exonerees, in the context of instances where the criminal justice system goes horribly awry. A case like a friend of mine named Daniel Villegas spent 19 years in prison for a murder he did not commit, went to prison when he was still a teenager, and it was on the basis of a coerced confession. And that brings up the question of, how do things like that happen? And in the course of the time I was a prosecutor, because of what I did, and because of what I experienced and what I saw, I ended up having to think about that a lot. Basically, the way that the justice system currently works, and it differs from state to state, but the theory is that a criminal defendant is presumed innocent until proven guilty beyond reasonable doubt by evidence that's admissible in court. And in general, in most jurisdictions, if not all of them, the theory is that the prosecution has a duty to turn over to the defense any evidence that falls into certain categories. And when the timing of when they're supposed to do that differs from state to state. There's been a big reform movement in New York because up until just recently in that state, they didn't have to turn over anything until right before trial. What I can speak to with the most knowledge is the rules in Texas. And although Texas has a reputation of executing the most people in the country and as most frequently, it has also ended up with probably some of the more progressive rules that govern when the prosecution is supposed to turn over evidence and what type of evidence they're supposed to turn over. And the backdrop is historically trials were what was here called by ambush, where every side went in, every side kept their evidence secret. Nobody had a right to know what the other side knew. And then you laid it all out at trial, and the chips fell where they fell. Over time, that got modified in criminal cases. And as a result, just during the time I was a prosecutor, there was a case involving an exoneree named Michael Morton that finally came to light. He'd been convicted. He'd spent, I think it was something like 27 years in prison for a crime he ended up not committing. It turned out that the prosecution had hidden evidence including DNA evidence. That finally came to light. The prosecution fought it every step of the way. Two different district attorneys fought it over the course of all the years, but he was finally exonerated. The legislature passed a statute called the Michael Morton Act, and that required that that turned the system from one where basically the state had no obligation to turn over anything unless the judge ordered it. And many judges, being ex-prosecutors in many parts of the state, were not inclined to order the state to turn over a lot of evidence. And there was some constitutional law principles that said, well, if it's really exculpatory, if it really proves that the defendant didn't do something, constitutionally you have to turn it over. But it wasn't the sort of thing that prosecutors could really get in too much trouble for. They might have to do the case over, but they weren't likely to lose their law license. Nobody was going to prosecute them if they hid evidence. Michael Morton Act basically said the judge doesn't have any discretion. If the defense asks for the evidence, the judge has to order that the state turn it over. And that was a big change. And then in the last few years I was prosecuting, a state ethics opinion came down, and that was an even larger change that even further expanded what was required to be turned over. But having the law and the ethical rules require that people do certain things doesn't tend to address the internal culture of a particular office. And that's usually where the problem lies. And I thought for a long time, as time went on, and I had certain experiences that I'll go into a little later to illustrate some points about, what is it that creates this problem in the first place? And I finally concluded that the core of the issue is, prosecutors are lawyers. They go to law school, they get trained to be lawyers. And a lawyer in certain fundamental ways is different from a prosecutor. Lawyers, when they're in law school, get trained in two fundamental philosophical principles. And the first of those is it's your ethical duty to keep secret or confidential anything about a case that your client wouldn't want the other side to know. That runs completely contrary to the rules that apply to prosecutors now, which is that anything that would tend to show that the defendant is not guilty of what he's charged with has to be turned over to the defense, and basically as soon as possible. But because prosecutors get trained in graduate school for 3 years, they get it drilled into their head that you keep your client confidences. Many of them are not able to make that adjustment on their own to the idea of, gosh, everything that's bad for my case, and that if my client were a human being, they would absolutely want me to keep secret. As a prosecutor, I'm supposed to turn it over to the defense because the defendant has a legal and constitutional right to know the weaknesses in my case. So unless you have an office that has a culture that's designed to change this way of thinking that's been drilled into the lawyers who serve as the prosecutors, you innately have a problem because they've been trained to keep it secret, while the rules basically require them to turn over everything that they've been trained and their instincts tell them to keep secret. And then the other problem is simply that lawyers also generally get trained in law school and going forward that, win. There's that scene out of the movie The Devil's Advocate with Keanu Reeves and Al Pacino, where at one point Keanu Reeves gets provoked into lose, I don't lose, I win, I'm a lawyer, that's my job, that's what I do. And that also gets trained into lawyers in the process of being trained in law school, that, you're there to represent the client, and the client wants you to win, and that's your job, is to win. And that also becomes a problem when you take lawyers and turn them into prosecutors if you do not address that way of thinking and try to re-educate people. And, every office pays lip service to the concept. Some of them do better than others. Some aspects of the situation are so blatant that nobody can deny it. But you get into a variety of problems that go from the subtleties to the institutional culture. And all of these things basically mount up. And in the end, you can have real problems with people ending up being charged and convicted of things that they just didn't do. I hit a point where when I was a prosecutor, I used to literally have to meet in stairwells with the defense attorneys on cases if there were things I needed to disclose, so that the management I worked for did not find out that I was complying with the ethical rules. Because it would have been a problem. I was going to do what I believed to be the right thing, but it was at some risk to myself. And I can give some concrete examples from what I went through, and it comes in a whole continuum of versions. I had one case, it's a misdemeanor DWI. On the scale of things that the criminal justice system handles, it's not an insignificant case, but it's not a felony. And the thing on that case was that the traffic stop had been conducted by a single state trooper. By the time we got to the point where there was going to be a hearing on the defense's motion to suppress, it had become clear we couldn't find the trooper. The trooper had resigned from the Department of Public Safety. Public Safety could not find them. If they couldn't find them, we were never going to find them. That was abundantly clear. The recent ethical decision said I had an ethical duty as a prosecutor to tell the defense everything that they needed to know in order to intelligently advise their client whether to plead guilty or not. My interpretation of that was they absolutely have a right to know that we can't find the witness we need to have to even be able to get past a motion to suppress the evidence. My supervisor said, don't tell him that. Don't tell the defense attorney that. I'm going to offer him a sweet deal, 3 days in jail. See if he takes it. So what I'm being told by the supervisor is, see if you can sucker the defendant and the defense attorney into pleading guilty to something we can't prove. So I called the defense attorney, who was something of a friend of mine, on the cell phone, told him, meet me in the stairwell, told him, we can't find the witness. There's no way that we can prevail on this motion to suppress. The supervisor's going to offer you the 3 days. Tell her to stick it. She'll dismiss the case. So he did, and she did, and there it was. Problem was, a lot of my coworkers might have not been as cognizant of what their duties were. They might have done it. The defense attorney would have had no way to know we couldn't find the witness. They might have thought it was a good deal. They might have advised the client to take it. The client might have pled guilty to something that we couldn't prove. The criminal justice system is based on the concept that, allegations are made, accusations are made, the police get called to an incident. They decide based on everything that they can see at the time, the evidence that they collect, whether or not there's probable cause. All that means is, I think the accused probably did what they're accused of. In El Paso, they submit it to the district attorney's office. With misdemeanors, some prosecutor looks at it, decides, yeah, based on what I'm seeing in the police report, I think the accused probably did it. They sign off on a form called an information. Now you're charged with a criminal offense. If it's a felony, they take the evidence to a grand jury, which is typically 12 people. They don't have to show them all the evidence. They don't have to show them exculpatory evidence. They present to them whatever they want them to see. Here in El Paso, that's usually police reports. If there's videos or photos, they'll present those to them. I don't know whether, grand juries deliberate behind closed doors. I don't know whether the cases I presented to a grand jury, anybody looked at the photographs, if there were photographs on a case. Maybe they did, maybe they didn't. I tend to trust juries, but they're behind closed doors. There's no way to know. They almost always find probable cause. It's an exceptionally low standard. And then somebody's charged with a felony, and off it goes. In that case I was just describing, for some reason, my supervisor thought this was a sporting event. And so we can't prove it. We can't even get past a motion to suppress the evidence. See if you can sucker them into a good deal. We'll chalk up a win in the win column. We'll move on. So that's, and I knew that person who was my supervisor for quite a while. I was surprised at the time it happened. I don't know why people do what they do, but that was the decision she made. And then I made the decision I made. And it was one of the things that made me start thinking in terms of maybe it's time to do something else. But that was one step on a continuum. I had another case where this was a child molestation case, first-degree felony, maximum sentence, life in prison. One day, the case agent detective called me and said, the child has recanted. I called the child's mother and said, the detective is telling me this. The child's mother said, yes, she told the therapist today it wasn't the defendant. So I ran into the defense attorney that afternoon on the elevator. I took him off the elevator. I said, here, I'll send you a written notice tomorrow when I've got some time, because I've got another case I've got to work on, meet with witnesses in a few minutes. But here's what the situation is. He jumped the gun. He sent a letter to the elected official demanding immediate dismissal of the case. And about an hour later, I have the elected official standing about a foot from my face, screaming at me about, why would you ever be forthright with the defense? And I'm thinking, okay, why would I ever tell the defense attorney that their client, that the victim, the alleged victim on a case, has suddenly started saying that the defendant didn't do it when the defendant is looking at life in prison. Gosh, elected official, I don't know why I would do that. And in that instance, I looked him in the face. I told him, well, I did it to protect you. And he thought that was a perfectly great idea because he was all about cult of personality.
Mm-hmm.
And he
so
was, yeah, go ahead.
Yeah. Let me stop you right there for a second. And so my understanding is from the police officers to the prosecutors to the judge, everybody has immunity.
They do.
If they send somebody to prison for exorbitant amounts of time and they got it wrong, oh well, we'll try to do better next time. Meanwhile, somebody's done 19 years and it just floors me that you can be so flippant in destroying somebody's life, and they have no recourse to get back any of those lost wages that they could have made. At the very least, I mean, if you're making minimum wage, you should get minimum wage times however many 40-hour weeks. There should be something in there for compensation, and there's not. You have to go through a whole nother process of doing a civil suit against the city or the county or state, whichever happens. And a lot of the times, I mean, you don't have the money. Maybe somebody's going to take it on contingency, maybe. But if it's not a high profile case, most likely no one's going to deal with it. And sorry about your luck.
No, fundamentally, and that's a doctrine that applies to civil cases. It's most commonly called qualified immunity. I've never studied the history of the doctrine in detail, but it has its roots in certain Supreme Court decisions. So the United States Supreme Court could do away with it if they chose. Some states have I think, written that into their case law or their statutes. But basically what it says is that fundamentally, if we let defendants sue police and prosecutors and things then basically every time anybody got charged and got acquitted or got the case dismissed, they turn around and they'd sue everybody involved on the state side, and our criminal courts would turn into family law courts where everybody fights over everything and the case goes on forever. And it's a theory with a slight foundation, in fact, but it is also exceptionally problematic because it does create situations where if the police or if the prosecutors on a case or the judge does things that are just blatantly improper, there's no recourse in a civil suit. And so that they're, at the very least, they're immune from being sued civilly. You can sue typically the jurisdiction that they work for, and that's what happens in cases involving the police. You can sue the jurisdiction that they work for if you can figure out what the right defendants are. Years ago, when I was doing civil work, I helped a friend of mine who was trying to sue sheriff and various federal law enforcement agencies over a search of a building where people ended up being held with guns stuck in their faces for several hours while law enforcement got 2 search warrants and tried to ransack the place and didn't find anything. And the problem that ended up, since he sued him in federal court, in the end, the federal court threw it out because nobody that he could identify as being the defendant was legally the proper defendant. And the court wouldn't tell you who the proper defendant was. They just said, none of the people you named are the proper. And he'd named everybody that anybody could think of. He'd named the county, the city, the police department, the federal agencies, the federal government, the individuals involved. There wasn't anybody left out, and yet none of them are the proper party defendant. So, and it was just over. There are theoretically certain recourses. Theoretically, prosecutors who step over the line, police officers who violate people's rights, theoretically, they could be charged criminally. And the system places a lot of weight on that idea. Well, that's a recourse. They could always charge them with criminal offenses. Well, typically no prosecutor is going to charge their own employees with criminal offenses for doing what they did, because they were usually acting under orders from the person who would file the charges in the first place. And typically it's the rare occasion that they're going to file criminal charges on the police, unless what happened was just so egregious or the evidence was so clear. And there are cases here in El Paso where law enforcement officers did get charged, and that had its own set of problems, because the ones I'm familiar with, there were cases I'm familiar with where the conduct appeared to me to be very egregious on the part of whatever part of law enforcement was involved, and no charges were brought. And then there are other cases where charges were brought, and the evidence I was aware of, I thought, the conduct at issue looks justified to me. So with police officers, typically that does go on. I am not aware of there practically ever being a case involving prosecutors. I think the man who was the district attorney who sent Michael Morton to prison here in Texas, by the time Michael Morton got exonerated, he was a judge. It was so blatant in that case that he did get disbarred, and they made him spend 10 days in the county jail for the 27 years or whatever it was that Michael Morton had done in the Texas prison. And that was the only time, apparently, that anybody in the United States has ever gone to confinement for any period of time for something that they did as a prosecutor. And then judges are typically even more immune, based on the same theory that, well, if they weren't immune, every defendant would sue them on every case, and the system would grind to a halt. I know that with a lot of the progressive reform movements, it's one of the things that they're trying to change, especially in regard to law enforcement officers. I think the tide is turning. I think eventually there will be at least a limitation on qualified immunity, but it hasn't happened yet, and I'm not going to give anybody a time frame for when it would. I just think that in the aftermath of what's going on with George Floyd and all of the other cases over the last many years, and public opinion is changing. And that's probably, in the end, that's the greatest hope. When it comes to compensation for people who have been wrongfully incarcerated, that varies from state to state. Some states have statutes that address it. Others have no provision for compensation whatsoever. Here in Texas, there is a statute. It does prescribe a certain amount of compensation for every year. It's not what I would call sufficient, but it's not skimpy the way it is in some of the states where frankly, the amount of compensation is embarrassing. The biggest problem here is that you have to have a finding of actual innocence. If you just get a new trial and the prosecution decides, well, we never really had any evidence anyway, so we're going to dismiss it, that's not a finding of actual innocence. So no compensation for you. You have to get a finding from a judge. And one of the things that the prosecution will frequently do in many places, and what they tried to do to my friend and colleague Daniel Villegas, who worked with me on the race for the new DA here that just resolved on Tuesday, they come to you and they offer you what's an offered plea. Basically, you've been in prison, something comes to light, you're one of the rare cases where you via writ of habeas corpus or some other means, you get a new trial. And the prosecution will go to you and say, well, we'll offer you an offered plea, and we'll have it be time served, and you'll get out the minute you say the word offered plea. What an offered plea is, it's like this. It's a constitutional doctrine. The U.S. Supreme Court ruled many years ago that it was required to be offered to defendants if they wanted to pursue it that way. It is legally the same as a guilty plea, but I did so many of them in cases in Washington State. Sometimes as a defense lawyer, you will have a case where your client says, I've been in jail pre-trial 30 days. I'm going to lose my job. I'm going to get evicted. I didn't do it, but I can't do this anymore. In the end, they make their decisions. You advise them, but in the end, if they choose to do that, after they've been advised that you choose to do that. Washington State was a place where if you pled guilty and then you later on denied that you committed the offense, even if you were innocent, they could revoke your probation, they could revoke your parole. And so an offered plea is basically this. The allocution is, I did not commit this offense, but I have looked at the evidence that would be presented against me to a jury, and I believe there is a substantial likelihood that a jury could possibly find me guilty beyond reasonable doubt, and therefore I want to resolve the case. So on these cases with exonerees, what often happens, and what they tried to do with Daniel Villegas, was they went to him and said, we'll offer you an offered plea, and you don't have to say that you're guilty. You can say, I didn't do this. It's the same as pleading guilty legally. And you'll get out today, Daniel. You'll get out today. And by that point, he'd been out after the writ of habeas corpus for probably at least 3 years. He basically was married. He had a couple of children. He's staring down the barrel of, I didn't do this. But if I go back to trial and somehow I lose, I'm going back for life without parole because it was a capital murder charge. And if I take the offered plea, I'll be out tomorrow. I'll be able to, I'll be able to raise my children. I'll be at home. Be able to have a job, support my family. And I know for him it was a struggle. Now his wife, who's a very strong person, told him, you didn't do this. You don't take that plea. And so they went to trial, and he was acquitted, thank God. And that was a case where they persisted in going to trial even after the judge threw out the confession on grounds it was coerced, and then threw out almost all of their other evidence that they tried to use on grounds that it was inadmissible or irrelevant or procedurally flawed in some way. And they still went and tried him a third time. Just relentless. And thank God, he was acquitted. One of the things that made the district attorney's race here that was so important was that the district attorney who had sent Daniel to prison originally had finally decided to retire. And so it boiled down to who's going to be the next district attorney. And when it came down to, there were 4 candidates to begin with. When it came down to the runoff, it was between the candidate I was helping, who had almost unseated the incumbent the previous race, and she was running again. And the other candidate was the prosecutor who tried to send Daniel Villegas back to prison for the rest of his life without having really any evidence, but had still done it. And so in my personal opinion, it really did boil down to a battle between good and evil. And thankfully, the right candidate got elected.
So I have another question. So as somebody who's been through the system, state and federal, for me, from the time that I got in, it seemed like the whole system was designed to bend you to in sort of like it's designed to coerce you to plead guilty and take a plea bargain because of what you're involved in, and if you're somebody who's never been locked up before, I mean it can be very it can be a scary situation. It's very dangerous in there. You have predators in there that not like predators, molesters and stuff like that. I mean, I'm sure they're there, but they're usually locked away in solitary confinement anyways. But you're in a situation where like all you're thinking about is, I'm hungry. They feed you hardly anything. If you're poor, you're not going to get it. You're going to be starving, basically. If you're weak, you're going to get preyed on and maybe get your food taken. If you're, if you don't have money for commissary, you're just counting down the days till you get to court so you can say, I'll take whatever you give me. Let's go, just get me out of here. So, I mean, that is a form of coercion. I almost laughed in the judge's face when she said, because it's before you get sentenced, they ask you, has anybody coerced you into doing whatever it is you're doing? And I was like, well, no, not overtly, but you're bending me to have to do this. And here's another myth that you hear when you're locked up and everybody's always talking, the prosecutor and the public defender, they're working together to hang me out to dry. I caught my public defender in a lie, to try to extend my trial, right? Because when I got in there, I knew that there was going to be a point. They had to test to make sure that the drugs, what the percentage was, how much they were, and all this other stuff. And the backlog was so long that they, wouldn't have been able to get into court in the 60 days that you have to, like, if you waive your rights to a speedy trial. I didn't. I said, no, I don't want to waive my rights to a speedy trial because I know you're not. I didn't say this, but I said, but I knew they wouldn't be able to test the drugs, and there would probably be a good chance that they'd have to throw the case out, right? So, when it came down to like a week before we were supposed to go to trial, I didn't have any witnesses. It was just, they did. I did what they said I did, but I was just trying to, I guess, play the system and play the odds, right? And the public defender said, well, I'm going to be on vacation, this date and this date. And it forced them to have to, extend the trial. And I said, and I stood up and I'm like, I don't agree to this. No, I'm not agreeing to this. And they really didn't give a damn what I had to say. And, this is what's going to happen. Well, the public defender called me. I guess he must have forgot that he said he was going to be on vacation. But he called me when he was supposed to be on vacation, and I'm like, I thought you were on vacation. And he was like, oh, well, this and that. So they were clearly working together to extend it so they could be able to get the drugs in time for this trial, and which forced me to have to go and hire an attorney because they were trying to hang me out with 15 years on a first felony.
That you have a whole gamut of that sort of thing that goes on in the system. And in my experience, it boils down to the individuals in play. I've been a public defender, both for the 5 years before I moved back here, became a prosecutor. After I left the district attorney's office, finally, when I couldn't take it anymore, I went back in, did defense work. I have paying clients. I have appointed clients. And it runs the whole gamut. The public defender's office here in El Paso, I think, is very good at what they do. And they are some of the most zealous defense attorneys I know. But I have dealt with, when I was a public defender, the public pretender title gets thrown around a lot by people. I don't think it's so much the status of public defender that determines anything. When I was a prosecutor, I clued in very quickly to the awareness that, doing a jury trial is a form of public speaking. Public speaking is generally not something most people are attuned to. And people can learn to do it and they can learn to be comfortable with it. But some people are naturally more suited to it than other people. And some people, it is a terrifying concept and they don't deal with it very well. And then they become averse. And so then they start engaging in behaviors to try to avoid it. And in most walks of life, that's not necessarily a problem. If you're going to be involved in criminal law as a lawyer, it's going to become a problem because, criminal law is the place where the jury trials happen. And as a prosecutor, I with the local defense bar, and we have a very collegial defense bar. It's not like in Seattle or in many, I think, larger cities in Texas, where there was animosity between the prosecution and the defense bar. Here in El Paso, it's more collegial. But that notwithstanding, as a prosecutor, I've relatively quickly developed an awareness of when I took a hard line on a case, which lawyers were going to probably do what they could to talk their client into taking it rather than go to trial. And then who were the people that if they didn't hear what they thought was the right thing, they were just like, okay, fight me for it. And that's just an issue with the individuals involved. I grew up very shy. I mean, painfully shy. But I also discovered when I was in high school, just serendipitously, that I actually liked public speaking when it was an audience. not one-on-one, but when it's an audience of people. For some reason, that changed the dynamic, and I very much enjoyed it. So I always liked doing jury trials because that's performing for an audience.
Yeah.
But, there are a lot of people who don't necessarily feel that way, even though they are prosecutors, even though they are criminal defense attorneys. So with that, you can run into exactly what you were describing in your case, where sometimes what you have going on can appear to be collusion, whereas what's really going on is maybe the lawyer just really doesn't want to do a trial. And so they start coming up with things to like put it off, or maybe, I can put it off enough to get the lab test. Well, then, I can go back to the client and say, you're cooked, guy. I mean, the lab test is here. Whereas the reality is, if you are in a court where you can push it and the judge will hold the state's feet to the fire and, okay, you go in with the lab test. Here in Texas, you get a directed verdict of acquittal. Yeah, those lawyers, I mean, they charge the barricades for their client, and in a situation like you were describing, they succeed. Somebody who's got issues with being averse to doing a trial, maybe they approach it the way you were describing. I don't think it's so much that people conspire with each other, but it's individual issues and how that affects it. And it is a problem. On behalf of the public defender's office here, I want to say they qualify as some of the more zealous defense attorneys that I know here locally. And there are a lot of very zealous private lawyers on the bar here also. I've always had a lot of admiration for the quality of criminal defense here in El Paso. But it is a problem.
Okay. Let's move to another question. So,
sure.
How hard does the federal, like the conviction rate and the federal funding that you get, the higher your conviction rate is that true, or is that another thing that you just hear in jail and then it just gets spun off into another conspiracy?
Yeah, that's there's a lot of talk about that, and after I left the DA's office here, I investigated to some extent. The biggest area where it was talked about here was with domestic violence cases. And where that arose was a lot of the funding the district attorney's office was apparently getting here was grant money. And there were a lot of rumors that you don't get any grant. It was a pay per case, and you don't get any grant money if you dismiss the case. And that was the big rumor. To this day, I don't know whether it's true or not. I tried to do some public information requests. I wasn't able to figure out how to phrase them in such a way that I can ever be sure I got information about every single grant the district attorney's office may have been receiving. The information I did get back on the grants that I was able to get information about indicated that it didn't have anything to do with per case. On the other hand, for a long time, the prosecutor's office here had an agreement with the attorney general on welfare fraud cases that was literally pay per case, and you get paid on a case unless you dismiss it. And if you dismiss it, there's no money. Mm-hmm. And so the only way those cases got dismissed was if the elected official of the first assistant district attorney approved it themselves, which was called never going to get dismissed. So, and eventually the attorney general's office came, or some authority came down and said you can't fee split that way, and that was the end of the welfare fraud cases here, because if there wasn't any money in it that way, the DA's office here quit bothering with them, so they all just suddenly went away, and the attorney general or whoever it was that was supposed to be prosecuting them in the first place took over. So that was an example of a case where, there is money in it. I suppose in a grant money situation, there could be money on a per case basis, and that could come in any form that is in the grant contract. But to some extent, it's also just a rumor. There are other aspects, what you're talking about being incarcerated, pretrial incarceration. That has been scientifically shown to greatly increase the rate at which people plead guilty to things, regardless of what the evidence is or isn't. It is a form of coercion. And it is one of the many aspects that's led to the rise of the people who are fighting to reform the whole cash bail system. And but that's also somewhat of a multifaceted issue, because no one should sit in jail because they're too poor to come up with a cash bail. And I have had many clients, and I have dealt with many defendants who, if you set their bail at $100, which meant they had to come up with $10 to a bondsman, they couldn't do it. Your defendants who are homeless, your defendants who have had such troubled lives, they have no family structure backing them. So there's nobody they can go to and say, can you get, I had clients from time to time who they might have had the money, but it's in the bank. Nobody can access it. They're not coming up with anything. So nobody should sit in jail just because they can't afford a cash bond. But I'm also not somebody, based on my experience with the system, I'm not somebody who's saying there should be no cash bonds and everybody should go on a personal recognizance bond, because the problem with personal recognizance bonds is, at least here in El Paso, they invariably come with a variety of conditions on your behavior while you're out. Whereas if you can afford a cash bond, you pay your bondsman, you keep in contact with your bondsman. I tell my clients, keep your bondsman happy. It usually doesn't take very much. They're mainly concerned that you don't disappear and you show up on time. And they've developed in the modern era very sophisticated systems to text your smartphone and tell you your court date's tomorrow, be there. And other than that, that's all you have to do. You can go on about your life. You're presumed innocent. It's pre-trial. If you're on a PR bond, you're going to be reporting weekly or every 2 weeks or monthly to the PR bond office. They're going to be drug testing you and alcohol testing you almost certainly. There may be curfews. You're jumping through all sorts of hoops. And a lot of people fail at one of those hoops somewhere along the way while their case drags on week after week, month after month. It's like being on probation when you are still not convicted of anything, or at least not the charge that you're accused of, and you're therefore presumed innocent, but you are being treated as if you were a probationer who's been found guilty, and you have all sorts of conditions. And if you violate any of those, you are in significant danger of going back to jail. And once you've blown your PR bond, getting you back out is going to be a real uphill battle. So I'm not in favor of do away with cash bond completely and put everybody on PR, because that has its own pitfalls. And there are a lot of people who, because of work responsibilities or transportation issues or whatever else, are going to end up failing to comply with some PR bond condition. My personal point of view is, let the bonding process work the way it does here in El Paso. They've got a pretty good setup where they're not draconian about the initial bonds that they set. Let people who can afford and choose to pay a money bond pay their money bond. I mean, they're adults. They're presumed innocent. If they can afford it, let them pay it. Let them go on about their lives while their case proceeds. But then set up a bond review process within 24 to 48 hours. And then somebody, if somebody hadn't come up with a bond in 48 hours, given the reality of what it's like to be in a county jail anywhere in this country, they're not going to come up with a bond probably if you leave them in longer. So in 24 to 48 hours, have a bond review. And then if they can show I can't make it, then you consider, is there something about what's alleged here or this individual's history of, and I would say not arrests, but proven offenses? Because, I mean, that's another problem with the system. If you go by people's arrests or cases they get charged with but didn't get convicted of, there's a lot of disparate treatment on the basis of ethnicity involved in that. But there's something about their history that indicates they might be a bona fide threat to public safety, or there's something about the what they're alleged to have done on the instant case that indicates there might be a problem with public safety, then yeah, maybe you consider that you have to take that into account in maintaining the bond at a certain level. But otherwise, review it and err on the side of putting them on a PR bond so that they're not sitting in jail just because they can't come up with the money. I've had innumerable clients who ended up sitting in jail for months on cases I was pretty confident that I could probably get them acquitted at trial, but the trial's not going to happen because of the backlog for months, if not longer. And they just can't make whatever bond is set. And then at the current moment, being incarcerated also brings with it the issues with the pandemic. And, here at first they were trying to play that off as we've got no problem in the jail. Well, they got a problem in the jail now, whatever it was back before they were willing to admit it. That they've been forced to admit now that, yeah, they have a problem that's proceeding to probably get out of control. So,
sorry, I didn't mean to interrupt you. So here's another issue that I see as a huge problem. And, most of the things that I'm referring to is just my personal case that I've been through, and some of the things that happened to me. The fact that you can stack charges to keep people, to boost up people's bail. And when it comes down to trial, you end up throwing out, or not trial, but when you go to plea bargain, 7 of them get dismissed and you plead to 1. That's kind of what happened to me. I sold to an undercover 5 different times, which you should have arrested me after the first one. There's no reason why we should have been going through that dance 4 more times. And it's just to me, it was just another way for them to stack it so I can't bail out. And to speak to the own recognizance, they let me out on my own recognizance, and I don't even think that I asked for it. They just let me out 3 days later because I didn't have any. It was like my first felony, and I think they really wanted to see how much trouble I was going to go and get into after that, which I did. I fell right into the trap. But I mean, I had no intentions of turning myself in once they let me go. So it was a matter of catch me if you can. I'm not surrendering.
And those are real issues too. And, sometimes when it comes to arguing on behalf of your client, if you're trying to convince a judge to do what you're asking him to do, you make the best argument tailored to the audience you're dealing with. And there have been times when I have told judges, and sometimes with defendants I've represented more than once and know them pretty well. And I'll tell them, let's say they get convicted at the end and they're on probation. Well, put them on a PR bond. It's a good preview of whether they'll be good on probation. And some judges think that sounds like a good idea. And there's some truth to it, maybe, but it's just an argument to try to get what's best for the client. Because in general, being held in the county jail while you're presumed innocent is never what's best for the client. But as the lawyer, you make whatever argument you think will get the decision maker to do what you are seeking to have happen in the best interest of the client. The stacking of charges, what I saw in the years I was a prosecutor, it wasn't as much aimed at bond issues as it was aimed at plea bargaining issues. And there was another aspect to it, which was even different than that. The plea bargaining issues was, well, if you charge them at the highest thing that you can conceivably see in the evidence in this police report, well, then you can offer to knock it down to a lower level of felony, or, amend it to a different charge with a lesser punishment. And it's a way of applying pressure. As with many things in our system, some of the aspects that philosophically our society thinks, well, this is the best system. The adversary system. It's okay, 2 men enter, 1 man leaves. It's like trial by combat, but with people using words. That creates, and that may be a better system than you have in some countries where you present the evidence to the judge and the judge decides everything. But it's got its own problems. The whole plea bargaining aspect and the stacking of charges. Yeah, in my experience, that was more to do with, well, you stack them up and then you can cut them a break and maybe they'll jump on it. And, and the system runs on plea bargaining. If everything was a trial, the system would grind to a halt. And in a fair number of cases, plea bargaining is probably completely appropriate. But having people locked up certainly applies a type of coercion. Stacking up the charges on someone can apply a type of coercion. You know, and in the real world, that comes down to how good your defense attorney is. You know, some of them are able to stand up against it. I know when I was a prosecutor, if I was dealing with somebody who had a lawyer who didn't hesitate to go to trial, it certainly modified the way I handled a case, because it came down to, do I feel like having a fight on this again or not? There's a woman here in town who's one of the most natural born trial lawyers and defense lawyers I've ever seen. And I've tried more cases against her as a prosecutor than probably any prosecutor in the county. And she won every time but one that I can recall. And toward the end of my time, you know, basically, if she had a case, I'd look at it and go, you know, do I feel like losing on this one again? And the answer is no, I really don't feel like going through that again. It's going to be really distasteful. And so, you know, we would have a talk about what do you, the defense attorney, think is appropriate to happen here. And it was usually, I think it's appropriate you dump your garbage case. And that was typically what happened. But, you know, that was a situation. And one issue you also get into with prosecutors is typically a district attorney's office is where people who are fresh out of law school and want to do criminal law or want to become trial lawyers, that's where they go. And is a system that is designed to train young lawyers. But, you know, young lawyers, a lot of lawyers are people, they grow up, they're often from privileged backgrounds, not always. I had coworkers who came from all sorts of different walks of life, but a lot of people, if you afford to get to law school and you didn't do it on a scholarship, you're coming from a pretty privileged background. So the whole system as it affects defendants is utterly alien to them. They get in there, they have no life experience. Suddenly they have the power to make decisions that affect the lives of the human beings that stand before them accused of criminal offenses. And they're kids fresh out of, they're 20-something kids fresh out of law school, never spent a night in jail typically. And there is a tendency to look at the defendants and not see them as human beings like themselves. And when you have a person who has power over somebody and they look at that person and they say, that is not a human being like myself, that is one of the roots of all evil. Because if you dehumanize someone and you have power over them, it removes a lot of the behavioral inhibitors that might otherwise apply. Just by virtue of humans being somewhat altruistic in their evolutionary programming. And it's a fundamental problem. And it's easy to fall into it. One of the ways that it manifests itself most clearly is with a lot of prosecutors, the first thing they look at is a person's criminal history. And oh boy, if there's a lot of arrests on there, there's a lot of charges, there's a lot of convictions, oh, it's a bad person. Well, then the evidence is suddenly secondary. The best prosecutors I ever knew, the thing I always tried to do, you don't look at the history of the person until you've evaluated the evidence in a case. And so, that way you're not being colored by, well, this person's got a lot of history, and you overlook, yeah, but I don't have a case. But many of my coworkers fell into the trap of, it's a bad person, I don't care what the evidence is or is not. And, it's a fundamental problem, but that can only be addressed by the culture of the individual district attorney's office, which is why the culture of the district attorney's office tends to determine whether a jurisdiction is oppressive on a systematic basis or not. And it's a fundamental problem.
So would you just by what you were saying about how they were, they come from a privileged, life, don't understand what it is to even be incarcerated or what somebody would even go through. I would suggest that, as a part of law school, you spend a night or two in jail and experience exactly what the people that you're trying to put in prison have to go through before you can actually even get into a position like that.
I always thought from the time I started being a prosecutor, and I've been a public defender for 5 years when I started being a prosecutor, I always idly thought that, frankly, yeah, every new hire at the DA's office ought to have to go spend a weekend in jail. And if you really wanted to recreate the experience, maybe 10% of the people who spend the weekend don't get out at the end of the weekend, and you leave them for a while not knowing when they're going to get out, and maybe then they'll really come to understand the experience. But no sheriff in any county is going to agree to that because of the liability. I mean, you put these fresh prosecutors in there and something bad happens to one of them, that's going to be a real civil liability problem.
Well, you wouldn't put them in the general population. It would be, I mean, and I doubt you would even put them in a real jail. You would have a facility that's just for them, just for the experience, so they can have the benefit.
I think the role playing could have something of an effect. I'm not sure your jurisdiction would necessarily direct the resources to it, and I also think that role playing is good up to a point, but what you can do though is you can certainly require all of your new hires to get a tour of the jail. I mean, I was a prosecutor here for 13 years. I never set foot in the county jail, either the jail annex or the jail downtown, under any circumstances, until I went back to being a defense attorney and then had to go visit my clients who were in custody. And and that was immeasurably mild compared to what I have no doubt they experience. Because, I go down to the jail annex to visit one of them. I check in through the Sally Port. I walk down the halls to go to whatever pod they're being held in. I'm meeting with them on the other side of the glass. There's no one else in those halls I'm walking to get to the pod they're in. First time I went there, I thought it's good that this is marked as to how to get back out, because if I got lost, I'd never find anybody to give me directions, because there's just nobody walking the halls. But it is still an oppressive enough experience just to have that minimal taste of it that, certainly I think that would be appropriate. When the new district attorney takes office here, I'm going to discuss the whole subject with them and see, maybe something like that could be instituted. Tours of the jail are certainly not something that a sheriff is going to feel there's liability issues. It can probably be worked out.
Experience some of the food.
Well, yeah, let them have some of the food. And the other thing that I've talked with my friend Daniel Villegas about is in the months between now and when the new district attorney takes office, record a video interview with him about what life is really like in a Texas prison. He spent almost 19 years. He can describe it in detail. He hasn't been exonerated that many years. And no doubt he will never forget the details of that experience. And I've talked with him, and he's happy to do it. About, I want to have a long conversation with you on video about what it's really like to end up in a Texas prison. And then I want to make every prosecutor at the DA's office watch this, so at least they've heard. Because my experience when I was a prosecutor is that it really does end up, and unless you're careful, it's pretty much anybody can start to slip into it. It's like a sporting event. And the number of years you get on somebody, that's like the score. And the more years, the higher the score. The DA's office here, when I worked there, once every month, they would have a meeting of all the lawyers. And if you'd done trials, you would report on, what the trial was, brief summary of the facts and the evidence, how it went. And the more years you got in prison on somebody, the louder the clapping. And it was degenerate. It was degenerate. Okay. When I was a prosecutor, I sent more people than I could ever count to prison. A lot of it was on pleas. A lot of it, they agreed to it. I did my best not to be oppressive. I did my best to err on the side of mercifulness when, unless the case was just so bad that it had to be handled accordingly. But but in time, what became abundantly clear to me was, it may be necessary for someone, because of what they've done, that they need to go and be incarcerated for a period of time. My personal standard was, if you have taken a human life due to your behavior, and I can prove it beyond reasonable doubt, the value of the life that's been taken has to be recognized. And a certain amount of prison time is my personal standard was going to be it's appropriate. And then the amount of prison time is going to be a negotiation, and it's also going to be based on an analysis of what did you do. Cold-blooded murder is going to be one thing. Drove drunk and killed somebody is going to be a different type of behavior. But, if you want probation and you've killed somebody, fight me for it in the jury trial. That was my personal standard.
Yeah. I agree with that. I 100% agree with that.
Yeah.
Even somebody who's been to prison, I mean, there are definitely the people out there that have done things that should be locked away.
Yeah.
But
the reality of that is they are a small percentage of the totality of people who get sucked into the criminal justice system in this country. And one thing that finally happened with me that was a change in consciousness, after I'd been a prosecutor about 10 or 11 years, I got transferred into a new court. The judge in that court was a person who was naturally inclined toward rehabilitating people. And I realized that I felt like I had done nothing in the years I've been a prosecutor except destroy things. Because you have to be mindful that it may be justified to send someone to prison, but it is a destructive act. It is destructive to the defendant. Maybe they deserve it. Maybe it's justified. It's still destructive. You shouldn't hide that from yourself. It's destructive to them. It's destructive to their family. It's destructive to their children if they have any. It, in some ways, can be destructive to the wider society. If someone is incarcerated, usually they're getting out sooner or later. They're probably going to come back to the community in which all of us live. If incarceration makes them worse than they were before, which is almost invariably the pattern, that is destructive to the community they return to. And so I sat down with the judge in chambers one day and I said, you've done drug courts before. I know, I see how you interact with people. Why don't we try an experiment? Why don't we try to see if we could actually rehabilitate people for a change? And she agreed. And so for the year I was assigned to that court, that's what we did. And I every day I was like, if the people I work for find out what I'm doing, I'm going to be looking for a job. But and we tried it. We picked people who typically, and it's for probationers. I mean, if people are going to prison, they're going to prison. But it was for probationers, and it was based upon a realization that many of these people, there's nothing bad about these people. Most of them were damaged as children because of their life experience, and so now they're not fully functional, and they have problems abiding by the various rules of society. They self-medicate, and that brings criminal offenses. But the theory was, what if I, as the prosecutor, took positions and made motions that gave the judge the cover to use her power as a district court judge to force the system to provide services to these people that might get them past the things that were getting in their way? And so the people that we decided needed that type of approach, we'd have them come in every week. They're probationers now, so there's no ex parte thing. So I could interact with them without it being, I'm not supposed to be contacting them because it's a pending case and there's the whole adversarial system. And we bring them in, and the judge would ask them, how are you doing? Do you need help with anything? Is there anything getting in your way? And we'd listen to them. Because the fundamental idea was that fundamentally, a lot of these people had never been treated like a valuable human being for one day in their life. And just having an authority figure like the judge dressed in the black robes up on the bench, where they're sitting above you, genuinely want to know, are you doing okay, and can I help you with something? And then listen to you. I could watch people's, I could see it in their face, the way that experience alone started to change the way that they thought about their life and themselves. And then we would work with them. And it was the type of thing where, I tell their lawyers, look, I'm not going to try to revoke these people's probation if they relapse. They have a little problem with their community service, they don't commit any new offenses, I'm not going to have a problem with them. I'm not here to lay a trap and set them up. And people had their missteps, but I don't remember anybody except one person who spectacularly crashed and burned in that process. But a lot of people, it did get them on the right track in the end. But it's a change in consciousness. The normal district attorney's office doesn't think anything like that. They're not there to help people. They're not there to rehabilitate people. They exist in cultures, inter-office cultures, where they treat it like a sporting event. They try to run up the score. It's all about beating the defense. The defendants are bad people, and that's why they deserve to be dehumanized and treated like something less than human. And I feel powerful by crushing these people, and that is an inherent trait in many human beings that is part of what makes a system as problematic or even evil as it is this somewhat natural tendency that if you have dominance over another human being, it can bring out reservoirs of cruelty that you may never have known were there, because it's a neurochemical rush to have power over another human being. And the tendency is, well, let me squeeze them, because that's even more of a rush. But the thing I learned in the process of conducting that experiment was that I never felt as powerful as when I was helping lift somebody up. But nobody in any prosecutor's office I know of ever gets training or experience in that type of approach. It doesn't exist. With our new district attorney here, I have hope that type of approach might start existing on a systematic level. I know her very well. I've known her for a long time. I've worked with her closely. And I plan to go back to the office and help her with the running of it. And I know she's committed to progressive reform. And I know, on the small number of cases where you do have threats to public safety or horrific offenses, she's tough. She's one of the toughest people I know. But she's also been a defense attorney she's a prosecutor at the beginning of her career as a lawyer. She's been a criminal defense attorney the last 15 years. She understands that the accused are human beings, and they have to be treated as human beings. One of the other things I learned was that, a lot of times people tell you, well, look at the defendant and say, that could be me, or that would be me if something was different. But a couple of years ago, before I quit being a prosecutor, I read an interview with the gentleman who's been the district attorney in Corpus Christi. And his point was, when he was 18, he got charged with the DWI. He went in with his mother because he couldn't afford a lawyer. His mother said, mijo, plead guilty, they'll be nice to you. So he did. And then he watched the guy who could afford a lawyer get off, and he thought, I need to be a lawyer. Went to law school, became a very successful defense attorney, decided that the system had problems, ran for DA, and got elected. And I read an interview with him shortly after he got elected, and they asked him, what do you want to be different about your office now that you're running it? And he said, well, I would hope that we would have some humanity, because that defendant standing there was me once. And when I read that, it was a change in consciousness. And part of what that taught me reading that was, if you really want to treat people you have power over as human beings, you can't just say, well, that could be me, or that might have been me if something had been different. You need to look at them and say, that person is me. And then you decide, based on what you know about the case, what you should do.
Yeah, that's an amazing point. And here's something that I've always thought is that, why is it that somebody who's been, like, for myself, I come from a family of law enforcement. All of my father's side, from my uncle to my other uncle, who was a guard at San Quentin, and my grandmother was one of the first female police officers in Berkeley Police Department. I don't know why I went down the direction I did. Well, I kind of do, but I mean, it's just because of pure laziness. But I feel like the best police officers should be people like myself who have been in that position, just like you're saying, and know how to deal with that element. You know what I mean? Because it's, I have experience as being an addict, all of these other things, but those aren't, that is just not something that people think about, because it's like, oh, well, you're a criminal, you're just going to help criminals. And that's not true. Defund the police. I don't agree with that at all.
No.
That is one of the dumbest things I've ever heard. Why would you want to do something like that? I think you need to reform the police department, and you need to, correct some of the things and some of the laws that protect them and make them not accountable for what it is that they do, and try to make things a little bit better. But to defund them 100% and not have a police department is not it is not it's not a smart thing to do.
Mm-hmm. And there's no question about that. And the defund movement, there are some complexities. I have no doubt it has its origins in the fact that in many of our larger cities, there has been a problematic history between the police and communities of color, no question. Mm-hmm. And that is complicated by the fact that if you study American history, it's clear that at least to some extent, and more so in the states that were part of the Confederate States of America, police forces began as slave patrols and groups that attempted to catch fugitive slaves and drag them back to where they'd run from. And then during Reconstruction and in the 100 years after the Civil War in some of those states, the very criminal justice system was used to replace the slave labor system with convict labor. You have all of those issues. Yep. And that doesn't necessarily directly apply to the cities that are in the northern states, but there's still many of our large cities have horrific problems with these sorts of issues. I know when I was in Seattle, the Seattle area is a bunch of small farming towns that apparently grew together into a huge urban sprawl. And so the urban zone runs from miles north of Seattle to miles south of Tacoma, halfway to the state capital in Olympia. And it's all one big, you would think it was one city if you didn't know, but it's a bunch of small municipalities that grew together, and they all have their own municipal police departments. And the officers in those departments were typically very good at what they did. They were professional. They paid pretty well. You usually had to have college, at least some college hours. A lot of them, you had to have a bachelor's degree to even get on the force. And if you didn't measure up, they punched your ticket in the probationary period. So they had a high caliber of personnel, but there were some of those departments that were really straight up about what they did. And then there were some of them that were a real problem. And there was one of them that I was public defender for, was a place called Tukwila. And I would get clients come into the jail, cast on the arm, and they're like, well, they broke my arm. And well, just out of curiosity, what were you doing right before that took place? Oh, I told them, you can't arrest me, bro. And I said, okay, well, what have you learned? Well, I don't know. What do you mean? I said, well, don't say that to a police officer here. Have you noticed the patrol cars are painted black and blue? Okay, so that always got a laugh. And then I tell them, okay, you got to plead not guilty, because if you want any hope of a civil rights lawsuit, you can never plead guilty. I mean, you plead guilty, you admitted that they had probable cause to do what they did. So it varies, and that was not an area that had any of the history that you get in some of the southern states, but it had its own issues.
And what you're referring to, though, is the 13th Amendment to the Constitution, which states that that no free man, or something about a free man, they're all free unless you've been convicted of a crime. Yeah. Then you can now be a slave to the state, so to say.
Effectively, the 13th Amendment was passed by Abraham Lincoln, and it formally removed slavery from being legal in the United States. And then the 14th Amendment followed along, and that was what provided more legal protections to people. Because one thing to say that you're not a slave anymore, but if you don't have any other protections, then, I mean, it may not be that much better of a status. The 14th Amendment came along and applied a lot more protections, but
it didn't stop
it didn't fix anything per se. But the defund movement, it grows out of that, and it grows out of the horrific histories that have existed in many of our large cities. And there's no denying that's where it comes from. And there's an immense emotional force that comes into play in these locations. And I'm familiar with I've done a lot of reading on progressive reform, criminal justice reform in the last year I was a prosecutor, the year, 2 years since I left. I'm very familiar with the issues. I'm very familiar with the philosophies. It seems to me, though, that in a fundamental sense, yeah, defunding is, the reality is, as our country went down a path over the last 40 years where we stripped away any social safety system, so that now, if you're mentally ill, well, good luck. If you don't have insurance, good luck.
Yeah.
People end up on the street. People end up, because of their mental illness, violating some sort of criminal law. Now they're in the system. What we have done is our social safety net, whatever it used to be, has ceased to exist over the last 40 years. We have taxed the police with being the only government entity that deals with any of these problems. Homelessness, police. Mental illness, police. All sorts of things, police. Okay. Police were never designed for these things. I don't believe the officers I've known, I don't think that they feel that in situations like that, they probably should be the people who are at the leading edge of the situation in terms of responding to the situation. And in some places they've tried to address it. Here they've made a start with trying to come up with trained professionals who will go out on calls involving homelessness or involving mental illness in particular. And so it's not just the officers who are not trained counselors in terms of psychiatric issues or addiction issues or homelessness issues. They have someone who goes with them who is trained and tries to deal with it that way. To me, the defund movement is basically, it's a recognition that we ask things of police forces that we should not be asking of police forces. And so maybe money should be redirected, or extra money should be found somehow to create other aspects of civil government that would address these, so that we're asking the police primarily to deal with dangerous behavior and not just mental illness and drug addiction and homelessness and those sorts of things. If you look at it from that point of view, and you talk about it, maybe refocus the police, that makes more sense, because you're not saying cut their funding, strip them down, decrease their manpower, do away with them completely. You're saying they've been given duties they shouldn't be being asked to perform, because that's not what they were originally designed to do, and it's not what they're trained to do. And sending people who carry guns to go deal with somebody who's so psychotic because he's off his meds that he's talking to a lamppost is not a good recipe for a good outcome. But it's what we do.
I agree.
So in that sense, there's a purpose to it, but not the way many people perceive it because of the word defund.
Yeah, I agree. I think it should be, funds need to be redirected. Police need to have more training for hostile situations. I mean, I listened to a Joe Rogan podcast, and he had Jocko, I can't remember, was that Wilco or I can't remember what his last name is, but he was saying, as somebody, he was a Navy SEAL commander, and he was like, we trained 6 months before we even go to do 6 months straight before we even go on a mission. And he said these cops, they get maybe 3 months of police academy, and then if you're lucky, they get a year of training, extra training.
Yeah, and that's exactly right. And I have occasionally used exactly that. Well, how long did it take you at the academy to become a police officer? And then, 3 months, 6 months, whatever it is. I don't remember what it is here. And then I'll ask them, and how many years did it take you to graduate high school? And everybody gets the point. But the other thing on that subject, in the years I've been a defense attorney, in the years I was a prosecutor, I saw a lot of things when it came to the police, and you do have individuals who probably should not be doing that job, or in some cases, absolutely certainly should not be doing that job. And I've seen officers, I thought they were good when they were uniformed patrol officers, and when they became detectives, they turned into something really different. And I'm watching a police interrogation, I'm thinking that's the most blatantly coerced confession I've ever laid eyes on. And that's against the backdrop of, I realized after I left the DA's office, I spent 13 years as a prosecutor. Nobody ever once gave me any training at all on how to recognize when a confession might be being coerced. The good thing now is typically on a serious case, they video record it. So at least you see what actually went on. But, I also want to say that I have known many officers who are an absolute credit to the community and a credit to their profession and a credit to what they do and a model for what all of them aspire to and what we all think a police officer should be. And they are models of why we call police officers heroes sometimes. And especially when I was handling intox manslaughter cases where someone had driven drunk and killed someone else in a collision. When I would talk to the officers about some of the things they dealt with at the scenes of those collisions, I can remember talking to a pair of them who'd been to the scene of a collision where the vehicle caught fire and they were trying to save the person in it, and they were unable to in the end because they were trapped in the car because of the damage. And what they described about what it was like to try to pull that person out and not be able to do it, I can't even imagine. But that is what those people do. Day in, day out. It's what they're paid to do. And here they're not paid what I would call particularly well. It's not a wealthy community here in El Paso. They pay them what they can. Our police officers have a difficult and dangerous job. And I'm not going to stand here having been a prosecutor and a defense attorney and say that they deserve the level of animosity that they are getting right at this present moment just because they wear a uniform. But I will also say that I have seen things that make my hair stand on end in the way that some specific individuals conduct themselves in cases. And something needs to be done with the system that tries to address that. Based on my experience, I personally believe that a lot of the power to reform the system lies with the district attorney's office, because it's the district attorney's office that can go to the police and say, if we see this type of behavior, we're not taking that case. If I look at this interview with the defendant, who for whatever reason was ill-advised enough to talk to you without a lawyer, and I see something that tells me that, you manipulated him into saying things, you use psychological techniques to get him to eventually break him psychologically and start saying things that have no basis in anything, which I've seen. You can go so far as you say, if I see that where the case is going away instantaneously, you can say, if I see that and it's clearly a practice on the individual, we're putting you on we're not going to take cases that you're involved in anymore list. I mean, there's a variety of ways they can do it, but it's the district attorney's office that has that power, more so than anything else. And that should not become a cause to say that the officers on the street need to live in fear of, well, what are they going to do if I do anything? Officers, they have a dangerous job. They don't, we live in a society that have gun that is armed to an extent that would make the European countries, if they really understood what it's like, they would probably faint. So, as a police officer, every day it's realistic that you can run into somebody with a bad attitude or a mental illness, and they're heavily armed, and there you are. And I've always thought in the times when I've talked with the district attorney elect here now about some of these issues, you tell the officers, you do what you believe you need to do to come home at the end of your shift. And then the district attorney's office takes the case and decides what they need to do with it to comply with the law and the Constitution and all the principles that go into that. And then if somebody demonstrates that they have a problem with their handling of things, there's a racism problem, there's any other sort of issue, you address that along the way. It's a district attorney's office that can do all of these things if they're motivated to do so. I believe we're entering a period now with people like Larry Krasner in Philadelphia and Chesa Bowden in San Francisco, where we're having district attorneys elected who are coming more from a point of view of, yes, we are going to take more of an approach that is interested in rectifying the mistakes of the past.
I agree. I agree with that 100%. So we're sitting at about hour and a half right now. This is a great conversation. A lot of good points. It's I love having conversations where we can both, just kind of back and forth and talk about different aspects of things. There's one last question that I want to ask you, and you can not answer it if you want. And I don't mean to put you on the spot, but as being a prosecutor for 13 years, was there ever a time that you lost sleep over somebody that you'd sent, or a number of people that you may have sent to prison at any given time? Like, did you ever have any regrets?
That's an excellent question. And in general, I tried to approach the job so that wouldn't ever be a situation. There is one case. And to give you a real quick rundown on it, it was a little girl in elementary school, and she alleged that, after school, she helped the teacher clean the blackboards, and then she took her books from the library, and then she went walking home. And she's walking down a dirt back road, and she was accosted by a young African-American man, probably in his late teens, early 20s. And he groped her from behind, and she was able to break away from him and run off. And they had shoe prints in the dirt road. They had photographs of those. The fundamental problem with the case was that they scooped up the only young black man they found in a 2-block radius. They did not ask the girl. They did no lineup. They did no photo montage or 6-pack, as it's commonly called. They just charged him with the offense. And when I had the case and I looked at it, and the shoe prints matched his shoe treads. They never tried to determine whether he had an alibi or not. That's not what detectives here typically do, which is something that needs to be rectified. I was relatively new as a prosecutor. If it had happened at the end of my career, I might have thought differently. But we did a trial, and at the trial, the girl identified him without hesitation. And I had no reason to believe at the time that there was a misidentification. But the thing that that now makes me, I'll never know. He got convicted. The jury gave him probation. And his response was, "I'm not doing any of that." And he didn't do a single thing on probation. And eventually the probation department filed a violation notice. The prosecutor was in the court at that time because it was a couple of years down the line. I'd rotated to another court. They filed the motion to revoke his probation, and he got the minimum sentence that the jury had given him as the underlying sentence. And at the time when I had the case, I was aware of some of the issues. I was not aware of them in the way I would be now. I had never been trained, and I didn't have the self-education I do now with how eyewitness identification can be faulty, especially if there's a difference in the ethnicities of the people involved. And when he didn't do anything on probation at the time, I didn't have the experience to know that when people have been convicted of something that they didn't do, there are some of them who say, "Well, I'm never going to comply with any of these conditions because I'm innocent." And for a long time, I'd never thought back about that case. But after I left the DA's office one day, it came to me, and I looked at it from where I stood then, 12 years later. And now I wonder, if I'd had that case at the end of my career as a prosecutor, I don't know that I would have gone to trial on it. I don't know. I don't know.
Yeah.
I might have been ordered to do it. The child sex cases were a hot button issue in the office. There were times when I got ordered to go to trial, and you need the job, but you can present the evidence to a jury in such a way that they are going to see what you think, and the outcome is typically predictable. So yeah, that's the one case out of all the ones that I handled. Yeah, I got very good in the last half of my prosecutorial career of if I thought there was anything wrong with it, I would do what I could to basically head it off. But that happened early. And it wasn't until I'd left the office that it came back to mind, and I started to wonder. And to this day, I don't know. The girl was very certain in her identification in the courtroom. But it wasn't like a similar case I had many years later where we had a positive DNA match, and that there's not going to be a question there. This was just an eyewitness identification, and she was very certain. But on the other hand, he was the only African American person sitting in that courtroom, and I'll never know. I'll never know.
You sparked something, a memory for me from when I was doing time, and it has to do with sex offenders, and how it doesn't matter whether you urinated in public, whether you were a 21-year-old that was convicted of statutory rape, even though that your girlfriend was 17, and consensual, and the parents, obviously might have pushed the issue or whatever that is. When I was locked down, we didn't know any of that stuff, and they all get lumped into the same category, right? And so there was a few times where I had to inflict bodily harm on people that came into the prison, and hopefully they PC up before they try to even get into the main population, but some of them don't. They and I had done an interview in one of my earlier episodes from it was 3 individuals that had a cell phone in their cell. And 2 of them were there for statutory rape. And I didn't really even think about this at the time, but after, I don't know if I had hurt those people, what I actually hurt them for. You know what I mean? What the case was, if it was a statutory thing or not. And I do you think that there needs to be a distinction as far as a reform? Because I mean, there's a definite difference between somebody who's either urinated in public, which is silly why they would even call that a sex crime, and but I mean, on the one hand, it is absolutely horrendous for somebody who molests a child that's in any manner, okay, but I don't see statutory rape as being something that even fits anywhere near that.
Yeah. And that's an excellent question. Here in Texas, the legislature has tried to address that somewhat. There's what's commonly called the Romeo and Juliet defense, which is, the age of consent here is 17. So if you're 17 or older, then it's not going to be that type of an offense. And then also there's the defense that if you're within 3 years of age, it may still be. If it doesn't matter if you're under the age of consent, if you're within 3 years of age, it's an affirmative defense. Realistically, here, jury is not going to convict on that if it's a consensual situation. To some extent, a jury here will not convict on that, even if the young lady, which is what it usually is at the time. Not always. I had some cases involving younger boys and somewhat older women. But the more common thing is the underage girlfriend. And so in this community, it was fortunate that the juries themselves would, to some extent, provide a backstop, and here more the age was if they're 15 or older, typically the juries here are very cognizant of the severity of what becoming a felon means to people in terms of the impact on their life. So they are careful about what they do. And I grew to believe that they made their decisions on the basis of they listened close to the evidence, and then they decided if what it described was a moral transgression. And if it did, well, then you're guilty.
Mhm.
And if it didn't, then you're not. And the technicalities of fine points of the law didn't necessarily affect how they decided. It was, was what you did morally wrong. And they would not generally look at a consensual relationship with an underage girl who was still a certain age as being so morally wrong that people should become a felon.
Mhm.
But it's a problematic issue, because the legal concept is that people under a certain age don't have enough mental development or life experience that even if they consented, that they legally they're allowed to consent. And that's where you get into the whole, what creates the whole issue. And here they changed the law a few years ago that required that your Romeo and Juliet defense, that it had to be shown as part of the affirmative defense that there was consent involved, which had been a slight flaw in the previous structure, but didn't change things too much.
Mhm.
And we did it, and we had a lot of cases that involved underage girlfriends. It was consensual. But because of the way juries handled them, it was relatively easy to say, well, realistically, I mean, I've done 100 jury trials. I know what they're going to do. They're not going to convict. And so you would work things out. But it becomes, it is a complex issue. And then when you tack on the aspect of sex offender registration, that makes it even more complex, because even then, if somebody didn't go to prison, you're still a sex offender. Texas has some provisions to deregister people. It's got a provision now that with the underage girlfriend or boyfriend scenario, the judge doesn't have to make you a sex offender if under certain specific conditions. But it's a complex issue, and it's hard to come up with a hard and fast rule because the real cases run the whole gamut from it's a genuinely underage girlfriend or boyfriend situation. It was totally consensual. But then you have situations where it might look that way, but if you look at it closer, there was psychological coercion involved, or maybe there was some sort of developmental disability mentally involved in the part of the younger party. And so it becomes very fact specific. Fundamentally, it is a reason why you have to have prosecutors handling those cases who are experienced and have good judgment. That's one of the more difficult issues to come up with any sort of solution for, because it is so case specific in terms of what you're dealing with. I mean, what was the situation?
Yeah, absolutely. I mean, there's no easy way around it. I mean, it's not easy for anybody. I mean, even when you think about people that work in the prisons and all that, I mean, they're doing time too.
Mm-hmm.
They're the things that they have to put up with, and I'm not trying to put them on a pedestal or anything like that. But I mean, if I'm going to take a look at both sides, you know what I mean, and try to give as somebody that's been there, I mean, they got to put up with a lot of things too. They get called names all the time. Sometimes they get sprayed with feces. It's a traumatic experience for them too.
Yeah.
And it just, I don't know, man. The whole system needs to be reformed or relooked at or readjusted or something. And I greatly appreciate the opportunity to have this conversation with you and talk about these issues. So right now, I mean, I don't know if you have anything that you want to plug, or this was more basically an informational conversation more than like a promotional thing for you as a guest.
Yeah. Frank, I'm not, I suppose you might say I'm in private practice at the moment. I do plan to go back to the district attorney's office here when the new district attorney takes office at the beginning of the year. So in a certain way, there's nothing for me to plug personally. What I do think of, based upon all of my life experience, from when my grandmother was killed up through the times I've been a public defender and then a prosecutor and now back to defending the accused. The system does need fundamental reform. The system is based upon a design which, not necessarily intentionally, but in its operation, dehumanizes almost everyone who is sucked into the system. And the dehumanization is like dropping a pebble into a still pond and the ripples spread out, because the accused are the first people dehumanized. But as was discovered in all sorts of contexts, if you read Nelson Mandela's autobiography, which I read 3 times in the course of my life, if you read writings of other people, if you have authority over other people and you use it to dehumanize them, it dehumanizes you. And so our system, to some extent by design, and to the rest of it just by its operation, dehumanizes everyone it touches in different ways. I know I saw the effect it had on the prosecutors I worked with, and there are some of them who are still good people. Many of the good people left sooner or later. There's some of them who stuck with it. They try to do what they can do on a daily basis to ameliorate the failings of the system, but it takes its toll. The system needs to be reformed. The process of reform is intricate and complex. And will be if we ever get serious about it, and I believe we're starting to in specific localities, it can be accomplished, but it's going to be a step-by-step process. But it does need to be reformed. It needs to be, the European prison systems do not have the problems that we do, because they don't treat people the way that we do. And in a sense, there's no reason that we need to treat the people the way that we do. I mean, the only thing that's different about their societies from ours are 2 things that I can think of. There's not anywhere near the guns on the street, but that's not the core of the issue. And they have much better social safety nets in their societies. And we have effectively nothing by now. And in a sense, our criminal justice system reflects our society, because our society is a form of ultra post-industrial capitalism that dehumanizes people by its working. So it's not really a surprise that our prison systems dehumanize people. When you live in the only industrialized country on the planet that has no universal healthcare system, it's no surprise that your prison systems dehumanize the people that get, and your criminal justice systems dehumanize the people that get sucked into them. Just as an example, years ago, I worked in a bookstore before I ever became a lawyer, and the manager there was from Ireland. She'd immigrated here. And one day, one of the employees said, "Well, I'm full-time now. Should I sign up for the corporate health insurance?" And I remember hearing the manager say, "Well, since we live in a country that will let you die in the gutter if you do not have insurance, yes, I think you should sign up for the insurance." It's no surprise our criminal justice systems dehumanize the people that they touch, because our society in fundamental ways dehumanizes the people it touches in many respects. But all of this can be addressed if we have the right change of consciousness in terms of how we think about what we do. And I do believe that the beginning of all reform comes from that moment when your consciousness changes and you look at the person that you have power over and you say, that person is me. Now, what should I do? But that is a difficult leap of consciousness to bring about unless you were very dedicated to it.
Yeah.
I'm hopeful that here we can do that.
Yeah, I do too. I do too. And that's why I do what I do, and take up the causes that I have been. And I think this is a great point to end on. And once again, I appreciate all your time, your transparency, and your honesty. And, hopefully we'll talk again sometime.
Absolutely. I'm very grateful for the chance to talk with you about these issues.
All right. Well, thank you, Curtis. And like I said, I appreciate everything. And congratulations on the win you just had with the new DA over in El Paso.
Thank you.
All right. Well, you have a good one, brother.
You too.
All right. Bye.